What does all this mean for the forthcoming law on assisted dying? Can parties come to an agreement on a way forward? Joining me now, the co-chair of the Joint Parliamentary Committee on Physician-Assisted Dying, Liberal MP Rob Oliphant. The committee's vice chair and Conservative Deputy Justice critic is Michael Cooper. There he is in the middle. And NDP House Leader Peter Julian. Thanks to all of you gentlemen for being here.
Good to be here.
Rob Oliphant, I'll start with you. There are a couple of, some of the things I wasn't surprised to read in the report, given conversations you and I have had previously. A couple things did surprise me. Let's start with people who are mentally ill or who have psychiatric problems. Why did you feel it was important to include them within the parameters of this report, and why did you think that they should be allowed to have access to this?
Sure. Thank you for that. And I just want to begin by thanking my co-chair, Senator Kelvin Ogilvie. And he and I have been sharing the leadership on this. And I just want to acknowledge that first,
yes.
that has been a tremendous partnership that we've had with the Senate and the House of Commons. In that process over the last month, we have looked at every issue that was implicated by the Supreme Court decision last February on how we could engage Canadians, both first in a conversation and then help the government prepare legislation and regulations and processes to facilitate the Supreme Court decision. And so we had to look at every issue. The Supreme Court was very clear that they did not pronounce on everything. They were only able to, or required to pronounce on the case that was before them. And they actually looked at a couple of cases, and that of two women who were adults and who had certain illnesses and were dealing with medical conditions that needed, they were seeking assistance. And so when we started to look at the full range of issues, we had to recognize that judges don't make law, legislators do, and so we had to consider everything. And the factors that came in were eligibility, who should get assisted dying, what professionals should be involved, how the process would work, whether there should be waiting times. One of those issues had to do with, would we develop a list of illnesses that were eligible and some that weren't? And so we decided that it was absolutely inappropriate for us to list certain illnesses that were eligible and certain that weren't. That's part of the medical profession. And so we had to recognize that whether it was psychological suffering or physical suffering, that was between a doctor and a patient to determine the eligibility for assisted dying. And so we're very clear that our task is not to take over from the physicians their job.
Okay, I want to get into another aspect, but I'll get your colleagues to weigh in on that particular one as well. Michael Cooper, do you have concerns around, I know there was a dissenting report from you and some of your colleagues. What are your concerns around opening this up to those who have severe psychiatric illnesses and who may want to take advantage of it with that?
Let me first say that the committee had a tough task and a short timeline. And I can say that every member of the committee worked in good faith as parliamentarians and as Canadians. Unfortunately, in some respects, although the main report does contain some good recommendations, it was not good in other areas. And our primary concern is that the main committee report goes well beyond the scope of Carter. The Supreme Court set a fairly clear roadmap for Parliament to respond to on the issue, for example, of minors. The Supreme Court was very clear in its pronouncement that physician-assisted dying applies only to competent adult persons. And with respect to vulnerable persons, you raised the issue of people perhaps with mental illness. One of the concerns that we have is that someone who is diagnosed with a mental illness would not be required to go through a psychiatric assessment. And that really is worrisome.
Right, except just to stop you there, Mr. Cooper, they would have to see two doctors, just the same as anyone else would be required to see two doctors. So presumably the two doctors could make an assessment as to that person's psychological well-being.
The evidence before the committee indicated not, and that's why the Canadian Psychiatric Association, for example, stressed the need for there to be a psychiatric assessment. We're talking about questions of competency and consent on a decision that's irreversible.
Sure. Okay, Peter Julian, just on this specific issue around mental illness and mental health, does the NDP agree that that should be open to doctor-assisted dying, that should be something that should be considered?
Well, Rosemary, I'd like to compliment the committee because particularly the recommendations around palliative care, something that the NDP has fought for a number of years. And if the government follows the recommendations and puts in place a palliative care strategy, that will make a big difference in the quality of lives of people who are in terminal stages in Canada. That being said, this is a report. It puts some barometers out, but it's actually the legislation that we will be voting for in the House of Commons, voting for or against. There'll be a free vote with the NDP. So what we strongly advise the government to do at this point is to be very balanced and respectful and sensitive as it proceeds in consultation now with the provinces to develop the legislation that will eventually come to the House.
Okay.
So I can't pronounce on the legislation until I see it.
No, I get that, but the report, is making. We're talking about the report, which will guide the government. I'm not saying they're going to put this in, but I just want everyone to sort of weigh in on some of them. And Rob Oliphant, I'll go back to you to talk about the issue of minors. This was surprising to me as well, and I would tend to agree with Mr. Cooper that it wasn't part of the Supreme Court decision necessarily. Why did you decide that you want this to be examined and perhaps put in place within 3 years for what you call so-called mature minors?
What we did was we looked at every issue that was before us and had to look at how the charter could apply and try to anticipate what could go on at a future date and we understood that the charter applies to all Canadians equally. At the same time, we recognized we had a concern that we didn't have enough information, enough expertise, and enough experience around that. I want to go back a little bit, though. It's very similar to the capacity issue around someone with a mental illness. We're not precluding the possibility of a psychiatrist being involved.
Yes.
Because that is a medical decision. And doctors do this all the time. If an attending physician needs a psychiatrist to have a consult, they'll call them. We trust our doctors with our living and our lives. We have to trust them with our dying and our deaths. And so they could do that. The same goes with minors. We believe that there should be consultation that goes on and physicians would get the kind of expertise they need. We're not quite sure how that should work. We don't have consensus guidelines yet, but that couldn't then involve a pediatrician or a pediatric psychiatrist. We're not precluding that. We're saying that's not a matter for legislators. That's a matter for the colleges of physicians and surgeons to work out with their bodies and make sure that we have the best medical practices on what we see as a medical procedure.
Yeah, I just want to hone in on that language before I bring in your colleagues there, medical, because you also said it's medical assistance in dying, and that is significant, that terminology.
Yeah.
Why are you saying that now? Does that mean it could open this up to people other than doctors, for instance, who want to help people die?
No, I think we're quite clear that we think that there should be attending physicians, 2 physicians. There could be a nurse practitioner in certain remote locations that are normally working under the direction of a physician. We're not opening that up. The name change has to do with the focus of this is on the patient, on the patient's rights, on the individual, the Canadian patient who wants to get help in this continuum of care and make sure that they have a physician or with them through that. So we've changed the name for a couple of reasons. We wanted it to harmonize with the Quebec law, which came before the Supreme Court decision, and so that focuses on medical assistance in dying, take the attention off the doctor, even though we're giving them an important role in this, but say the attention is on the patient.
Right.
The patient has rights, and we want to ensure that their rights are given and their vulnerabilities are protected.
Okay, Michael Cooper, back to you. Is there anything that you do agree with in the report, because you have this dissenting report with some concerns? Is there anything that you do agree with and you think absolutely has to be in the legislation?
Well, one good part of the report was the emphasis on the need for a national strategy on palliative care. There have been a whole series of Senate reports, for example, that have recommended this for some time. Now that physician-assisted dying has become a reality, it is absolutely imperative, it is absolutely essential that people across Canada have access to palliative care. That's something, for example, that the CMA recognized and the committee in its main report recognized.
And Peter Julian, anything that you think has to be in there? And you can weigh in on the issue of mature minors as well if you want there.
I think there needs to be a very careful balance. On the one hand, you have unimaginable pain and suffering people with chronic conditions. On the other hand, having worked with the disability community before I was elected to Parliament, there are some concerns about the possibility for abuse. So the legislation has to get it right. I think the report is a good, solid first step, but what happens next is even more important. And taking that balanced approach and a sensitive approach to developing the legislation that then comes forward to the House of Commons is critical. So I can commend the committee. And yes, there are aspects of the report that we can discuss and debate, but it's really the legislation that I think all Canadians will be looking to.
Sure. And Mr. Julian, you said it would be a free vote for the NDP. Mr.
Yes.
Cooper, will it be a free vote for your caucus?
The leader, Rona Ambrose, has been very clear that it will be a free vote, and quite frankly, this is something that all members of Parliament need to look at the decision, look at the report, the dissenting report, talk to their constituents, and look to their conscience in making a decision.
And Mr. Oliphant, you may not know the answer. I'm not sure I know the answer for your party. Is it a free vote or not, from your understanding?
What we know is that the Minister and the Prime Minister want to see legislation and examine that legislation to see whether it meets our criteria for free vote. We're very clear as a party that the Charter of Rights and Freedoms is one of the central foundational understandings of Canada as well as our party, and they're going to look at the legislation and make a decision on whether or not this will be a free vote or a whip vote. I have not been told, and I haven't seen the legislation though because it hasn't been written. So I always like to do evidence-based decision making, and I'm looking for the evidence before we hear how that vote will go.
Okay, listen, it's a very sensitive topic. I appreciate you all having that respectful debate. Thank you very much, gentlemen.
Thank you.
Thank you.
Okay, Rob Oliphant, Michael Cooper, and Peter Julian. Lots more on this story coming up, but first we want to hear from you. This is